All rise, we will obey. The International Criminal Court is now in session. Lord John to Court Panel International at Oijust. Please be seated. We will answer.
Good morning, Mr. President. This is the second situation in the Central African Republic. Case reference ICC 0114, and for the record, we are in open session.
And Judge Erdebasuren Damdin. I note for the presence of the authorities of the Central African Republic, the defense team, the Office of the Prosecutor, and the Office of Public Counsel of Victims. I take it that the attendants or attendees are the same as ones appearing on the list, which the court officer kindly provided to the chamber before the hearing. If the composition of any of the teams has changed, please notify the court officer by email. The appeals chamber is today delivering its judgment in the appeal filed by the defense of Mr. Edmond Beina against the decision of Pretrial Chamber 2 of 12 September 2025, entitled Decision on the Central African Republic Challenge to the Admissibility of the Case against Edmond Beina. I shall refer to the decision as the impugned decision. This is a non-authoritative summary of the Appeals Chamber written judgment in the appeal. The written judgment is the authoritative text, and it will be notified after this hearing. I now move to the background to the appeal proceedings. Pretrial Chamber 2, hereinafter Pretrial Chamber, on 7th of December 2018, issued a warrant of arrest against Mr. Beina for crimes against humanity and war crimes allegedly committed in Guyana between at least 1st February to early April 2014. On 3rd of May 2022, the Cour pénale spéciale, hereinafter CPS, in the Central African Republic issued a warrant for the arrest of Mr. Beina. In June 2024, Mr. Beina was arrested in the Central African Republic, and in October 2024, the Central African Republic challenged the admissibility of Mr. Beina's case before the court. Hereinafter, admissibility challenge. On 12 September 2025, the pretrial chamber issued the impugned decision in which it determined that the case against Mr. Beina before the court is inadmissible under Article 17(1)(a) of the statute. The defense for Mr. Beina, hereinafter the appellant, appealed the decision, raising 5 grounds of appeal. I now move to the appeals chamber judgment. Today's appeals chamber judgment is unanimous. For reasons that I shall proceed to outline, the impugned decision is confirmed. Ground of appeal 1. Under the first ground of appeal, the appellant submits that the pretrial chamber erred by distinguishing between different organs of the Central African Republic in its assessment of whether the Central African Republic, as a state within the meaning of Article 19.2b of the statute, brought its admissibility challenge at the earliest opportunity in accordance with Article 19.5 of the statute. The appeals chamber recalls its consistent jurisprudence that Article 19.5 of the statute requires a state to challenge admissibility as soon as possible, once it is in a position to actually assert a conflict of jurisdictions, and that admissibility proceedings should only be triggered when a state is ready and able, in its view, to fully demonstrate a conflict of jurisdiction on the basis that the requirements set out in Article 17 are met. The appeals chamber notes that the pretrial chamber, in line with the aforementioned jurisprudence and based on the submissions before it, carried out a holistic examination of the timeline of the relevant events and concluded that prior to August 2024, the state was not in a position to determine that there was a conflict of jurisdiction, nor could it have sought to demonstrate that inadmissibility of the case before the court at an earlier juncture. The appeals chamber emphasizes that, as correctly assessed by the pretrial chamber, what matters is at which point in time, taking a comprehensive view on the question of state for the above purposes, the Central African Republic was in a position to actually and fully demonstrate the jurisdictional conflict. In light of the foregoing, the appeals chamber rejects the first ground of appeal. Grounds of appeal, second, third, fourth, and fifth grounds of appeal. Under the second, third, fourth, and fifth ground of appeal, the appellant submits that the pretrial chamber erred in its assessment under Article 17.2c of the statute by considering as irrelevant and or unsubstantiated its submissions relating to the Central African Republic's judicial system as a whole and other comparable cases. According to the appellant, these submissions showed the unwillingness of the Cour genuinely to carry out the proceedings against Mr. Beina. Concerning the fourth and fifth grounds of appeal, the appeals chamber recalls that while human rights standards may assist the court in its assessment of whether the proceedings are or were conducted independently or impartially within the meaning of Article 72c of the statute, this court was not established to be an international court of human rights, sitting in judgment over domestic legal systems to ensure that they are compliant with international standards of human rights. It is not for the court to pass judgment generally on the internal functioning of the domestic legal system of states in relation to individual guarantees of due process. The appeals chamber further recalls that unwillingness within the meaning of Article 72c of the statute is primarily concerned with the situation in which proceedings are conducted in a manner which would lead to a suspect evading justice as a result of a state not being willing genuinely to investigate or prosecute. As such, the notions of independence and impartiality under this provision must be seen in this light. The Appeals Chamber notes that the pretrial chamber, in accordance with the above-mentioned established jurisprudence of the Court, found that it did not need to assess whether the proceedings against Mr. Beina before the CPS in the Central African Republic are or have been conducted in a manner which is inconsistent with an intent to bring the person to justice, given that it had not been established that these proceedings are not being conducted independently or impartially. The Appeals Chamber further notes that pretrial chamber considered that CPS has a witness protection mechanism, duly assessed the appellant's submissions in this regard, and found that there is no information before the chamber suggesting that witness in the proceedings against Mr. Beina would be deliberately exposed to or intentionally left unprotected from reprisals. In light of the above, the Appeals Chamber finds that the appellant has failed to show any error in the pretrial chamber's assessment of whether the proceedings against Mr. Beina before the CPS are being or have been conducted independently or impartially, or in a manner inconsistent with an intent to bring Mr. Beina to justice. Therefore, the Appeals Chamber rejects the fourth and fifth grounds of appeal. Consequently, and noting the appellant's submission that the third ground of appeal is fundamentally linked with the fourth ground of appeal, the Appeals Chamber deems it unnecessary to entertain the appellant's arguments under the third ground of appeal. Lastly, the Appeals Chamber notes the appellant's contention under the second ground of appeal that the pretrial chamber, in essence, reversed the Central African Republic's burden of proof to show that the case against Mr. Beina before the court is inadmissible, when it dismissed the appellant's submissions alleging a lack of independence and impartiality of the Central African Republic judiciary and an absence of effective witness protection mechanisms in the Central African Republic. The Appeals Chamber recalls a state that challenges the admissibility of a case bear the burden of proof to show that the case is inadmissible. The Appeals Chamber notes that this was the approach adopted by the pretrial chamber. The pretrial chamber assessed that two-limb test under Article 17(1)(a) of the statute on the basis of the information provided by the Central African Republic authorities and in light of the appellant's submissions. This is to be distinguished from finding that the appellant failed to substantiate how the general information it provided concretely impacts the proceedings against Mr. Beina. In this regard, the Appeals Chamber recalls that it is an essential tenet of the rule of law that judicial decisions must be based on facts established by evidence, and crucially, that providing evidence to substantiate an allegation is a hallmark of judicial proceedings. Accordingly, the Appeals Chamber finds that appellant has not demonstrated any error in the approach of findings of the pretrial chamber. Therefore, the Appeals Chamber rejects the second ground of appeal. In concluding, for these reasons, and for the reasons stated more fully in the written judgment, the appeals chamber unanimously rejects the appeal and confirms the impugned decision. This brings us to the end of the summary of the appeals chamber's judgment. I would like to thank the legal team that assisted me in this appeal. The court reporters, interpreters, and other registry staff for their valuable assistance today in holding this hearing. The hearing is adjourned.
All rise. We would away.